It finally happened. Donald Trump indicted and arrested. He's the first ex-president charged with a crime. Or as Trump put it, he has been indicated. Indicated with 34 felony counts of falsifying business records in the first degree. Now, as we'll talk about later, the number of felony counts is not a good proxy for the seriousness of the crimes, especially here where it looks like everything relates to the same nexus of facts. But first things first, this is the first time in history that a former president of the United States has been indicted. Although it's worth remembering that the justice system actually frequently holds elected officials accountable. Vice presidents have been charged with breaking the law, governors, congresspeople, mayors, and all sorts of other politicians have all gone to prison for committing crimes because in America, no one is supposed to be above the law. Of course, if you live outside of Illinois, your odds get way better. Nevertheless, Trump posted that he was shocked that he was treated like some regular Joe. He posted, heading to Lower Manhattan, the courthouse seems so surreal. Wow, they are going to arrest me. Can't believe this is happening in America, MAGA. Though Trump did get a little special treatment because he was allowed to forego the usual perp walk and mugshot, which anyone else would have had to go through. But the timing of the indictment caught most people by surprise. News sources had just reported that the grand jury was going on hiatus until May without indicting Trump. So score one for the confidentiality of the grand jury system. But now that Trump has been arrested, arraigned, and released on bond, the indictment and statement of facts are public, so let's think like a lawyer and break it all down. Now, Donald Trump has been indicted for 34 counts of falsifying business records. And during our last video about the New York case, we discussed the possible facts that would give rise to an indictment for falsifying records. Every New York business is required to keep certain business records, and New York Penal Law section 175.10 makes it a crime to delete, alter, or make a false entry in the business records of an enterprise with the intent to defraud. To get a conviction for falsifying business records, the government must prove that Trump either made or caused someone else to make a false entry to his company's business records. And a defendant who requests that someone else do the actual work of recording a false business record is just as criminally liable as if they did it themselves. Now, according to the Manhattan DA's indictment and the attendant statement of facts, the DA is alleging the following facts. The records concern a catch-and-kill scheme with AMI, the parent company of the National Enquirer. The idea was that the National Enquirer would help Trump win the presidential election by finding negative stories about him and then buying the rights to those stories. The plan was for AMI to then conceal those stories rather than publicizing them. According to the New York indictment, the scheme went from August of 2015 to December of 2017. The first one was to pay off a doorman who worked at Trump Tower. The man claimed to have a story about Trump having a secret love child, and AMI paid him $30,000 to keep quiet. The statement of facts says, quote, AMI purchased the information from the doorman without fully investigating his claims, but AMI CEO David Pecker directed that the deal take place because of his agreement with Trump and Michael Cohen. The parties subsequently decided that they thought the doorman was lying. The second incident involved Playboy bunny Karen McDougal, who the statement of facts refers to as woman number one. AMI arranged to pay McDougal $150,000 in exchange for the right to her story about an alleged affair with Trump. AMI told McDougal that she would get to write articles for AMI publications and would be featured in cover stories about her other exploits with famous men. As we discussed in our last video, linked below, AMI CEO David Pecker had a conversation with his lawyer about the scheme and promptly backed out of the deal. AMI entered into a non-prosecution agreement with the New York DA, where it admitted to unlawful conduct, including making false business records to conceal the purpose of the $150,000 payment to McDougal. Now, that being said, the doorman and McDougal payments don't seem to be part of this indictment because they're outside of the 5-year statute of limitations. And although Pecker and AMI stopped participating directly in exchange of money, they continued to broker deals for Trump, including facilitating the settlement of the Stormy Daniels payment. David Pecker allegedly told the grand jury that he brokered an NDA between Daniels and Cohen. Quote, shortly after the Access Hollywood tape became public, the AMI editor-in-chief Dylan Howard contacted Pecker about Stormy Daniels, who alleged she had a sexual encounter with Trump while he was married. Pecker told Howard to notify Michael Cohen. Dylan Howard testified that he communicated with Cohen about Daniels and also helped Daniels find lawyer Keith Davidson. And according to the DOJ's filings against Cohen, Howard and Pecker contacted Cohen through an encrypted app to let him know that Daniels was close to a deal with a media outlet to spill the beans about her affair with Trump. And the National Enquirer head honchos then negotiated the $130,000 settlement and also confirmed the NDA with Davidson. And the statement of facts confirms that Cohen and AMI admitted guilt in connection with the payoffs of McDougal and Daniels in the federal matters. Now, 12 days before the general election in 2016, Cohen drew down $130,000 $100,000 on a home equity loan, deposited into a shell account, and then paid Daniels off. After the election, Trump started paying back the initial $130,000 payment to Cohen, but he increased the amount to a total of $420,000. Now, these checks apparently came from the Donald J. Trump Revocable Trust, which was created in New York to hold the Trump organization's assets during his presidency. Later checks came from Trump's personal bank account. In total, 11 checks were issued for phony purpose, legal services. Trump signed 9 of those checks, and according to the indictment, each check was processed by the Trump organization and illegally disguised as a payment for legal services rendered pursuant to a non-existent retainer agreement. In total, 34 false entries were made in New York business records to conceal the initial covert $130,000 payment. And the indictment concludes that the participants in the scheme took steps that mischaracterized these documents for tax and election-related purposes, to conceal the true nature of the reimbursements, and to hide the reimbursements in total. So why 34 counts, and what records did Trump allegedly falsify? Well, prosecutors charged each false entry as a separate count. For example, there are 4 counts related to a single payment that was made to Cohen on Valentine's Day in 2017, each count related to a different document or business record. The first was related to an invoice for that payment. Quote, the defendant made and caused a false entry in the business records of an enterprise, to wit, an invoice from Michael Cohen dated February 14th, 2017, marked as a record of the Donald J. Trump Revocable Trust and kept and maintained by the Trump organization. The second count related to that payment was for the making of a, quote, false entry in the detailed general ledger for the Donald J. Trump Revocable Trust, bearing voucher number 842457 and kept and maintained by the Trump organization. The third count, and I promise we are not going to go through all 34 of these stupid things, was also for a false entry in the general ledger. The fourth count related to that payment that was when Trump, quote, made and caused a false entry in the business records of an enterprise, to wit, the Donald J. Trump Revocable Trust, account check and check stub dated February 14th, 2017, bearing check number 000138 and kept and maintained by the Trump organization. So, the business records for that one payment are the check and the check stub, and an invoice from Cohen, a voucher for that account, and a voucher for another account. And the DA basically uses the same pattern for all of the other counts. It's basically one count for every check or invoice. Now, this isn't required, but it's also a totally normal way to charge someone. Now, there has been a ton of breathless reporting about 34 felony counts, but a prosecutor has discretion here. They're not required to list out every single act that was part of a general criminal scheme. But by the same token, it's also a totally normal way of going about writing an indictment, and it's done all the time.
Remain calm! All is well!
So basically, you can't conclude anything from the fact that there's basically 36 different felony counts. Now, an additional wrinkle here is that for a charge of falsifying a business record to be a felony in New York State, it has to come with an additional requirement of intent to defraud. Now, under federal law, generally speaking, intending to defraud has a narrow construction. But New York State law interprets intent to defraud much more broadly, so that the prosecutor can establish intent when the defendant acts for the purpose of frustrating the state's power to faithfully carry out its own law. In layman's terms, that means that the government doesn't need to prove that Trump falsified business records for the purpose of depriving someone of money or property. The government only has to show that Trump did something to frustrate the regulatory authorities of New York. And New York courts have found such intent when a defendant did things like making covert contributions to a political campaign, covering up an alleged sexual assault, misleading a patient's relatives about the patient's treatment, and even operating a motor vehicle without a license. But this is certainly a point of controversy, and it's likely a legal issue that will be dealt with by the judge before the factual questions ever reach a jury. But the statement of facts does try to justify the charges. The most significant evidence that Trump knew what Cohen was up to with the intent to defraud was a conversation he had with Cohen about the McDougal payments. Quote, Cohen told Trump he would open up a company for the transfer of Karen McDougal's account and other information, and stated that he had spoken to Chief Financial Officer for the Trump organization, Alan Weisselberg, about how to set the whole thing up. Trump asked, so what do we got to pay for this, $150? And suggested paying by cash. When Cohen disagreed, Trump then mentioned payment by check. After the conversation, Cohen created a shell company called Resolution Consultants, LLC, on or about September 30th, 2016. But the prosecutor will need to prove that Trump knew about the Daniels payments too, and that he agreed to Cohen's payment scheme. The statement of facts alleges that Trump didn't want to pay Daniels directly, so he asked Cohen to do it. Quote, Trump did not want to make the $130,000 payment himself, and asked Cohen and Weisselberg to find a way to make the payment. After discussing various payment options with Weisselberg, Cohen agreed he would make the payment. Before making the payment, Cohen confirmed with with Trump that Trump would pay him back. The statement of facts alleges that Cohen made the payment through a shell company with Trump's blessing. Quote, on or about October 26, shortly after speaking with the defendant on the phone, Cohen opened a bank account in Manhattan in the name of Essential Consultants LLC, a new shell company he had created to effectuate the payment. He then transferred $131,000 from his personal home equity line of credit into that account. On or about October 27th, Cohen wired $130,000 from his Essential Consultants LLC account in New York to lawyer B to suppress Stormy Daniels' account. Now, the statement of facts also goes into detail about Trump Organization CFO Alan Weisselberg agreeing to pay back Cohen more money than Cohen paid out, so that Cohen could characterize the payment as income on his tax returns instead of a reimbursement, and Cohen would be left with $180,000 after paying approximately 50% in income tax. Finally, Weisselberg added an additional $60,000 as a supplemental year-end bonus. So the statement of facts indicates that Trump knew about his arrangement with Cohen. Quote, Trump, Weisselberg, and Cohen then agreed that Cohen would be paid $420,000 through 12 monthly payments of $35,000 over the course of 2017. Each month, Cohen was to send an invoice to Trump through Trump Organization employees, falsely requesting payment for $35,000 for legal services rendered in a given month of 2017 pursuant to a retainer agreement. At no point did Cohen have a retainer agreement with Trump or the Trump Organization. And the part about no retainer agreement is key, since Trump may argue that he was simply paying Cohen for legal services, which is what he indicated in the business records. The statement of facts also goes into some detail about how each payment was invoiced and made, and I think this detail is important. Once the election was over and Trump had won, he tried to back out of paying Daniels at all. Quote, Trump directed Cohen to delay making a payment to Stormy Daniels as long as possible. He instructed Cohen that if he could delay the payment until after the election, they could avoid paying altogether, because at that point it would not matter if the story became public. This could end up being a key allegation because it shows that Trump's motivation was to influence the election, not to protect his family from disclosure. Finally, the statement of facts alleges that Trump tried to pressure Cohen to lie about their arrangement. The pressure campaign included Trump tweeting at Cohen to stay strong and not flip, and the DA also says that a different unnamed Trump lawyer approached Cohen about representing Cohen in his criminal case, offering to help him maintain a, quote, back channel of communication to the defendant. In June of 2018, the lawyer wrote to Cohen urging him not to cave by pleading guilty, but Cohen did in fact plead guilty in August of that same year. Now, as we talked about, these are only felonies if there's an intent to defraud and also an intent to commit another crime or to conceal a commission of a crime. So what's the second crime in this case? Well, the indictment and statement of facts don't say, and New York law doesn't require that the prosecution identify the second offense at this stage. However, you can bet that there will be some motion practice to force the government to issue a bill of particulars to actually identify what these crimes are. However, in a press conference, Allen Bragg identified 3 general areas of law that he alleges that Trump intended to break.
The scheme violated New York election law, which makes it a crime to conspire to promote a candidacy by unlawful means. The $130,000 wire payment exceeded the federal campaign contribution cap. And the false statements in AMI's books violated New York law. That is why Mr. Trump made false statements.
So Bragg mentions that the $130,000 payment to Stormy Daniels could have violated the federal campaign contribution caps. Because the hush money payment was intended to benefit the Trump campaign, it could be considered an in-kind contribution. The FEC limits individual donations to $3,300 per individual per candidate, and in-kind contributions are counted the same as a cash donation. So the $130,000 would be way over that limit. As we covered before, there's a controversy about whether a federal crime can be used as a predicate for an underlying crime in New York State. And then there's also the state conspiracy allegation. New York elections law section 17-52 covers conspiracy to promote or prevent an election. Section 17-52 requires proof of a conspiracy among 2 or more people to promote the election of a particular person to public office. Co-conspirators could include Trump, Cohen, Davidson, Howard, and Pecker. The prosecution doesn't need to prove that the defendant committed the second crime, just that the defendant intended to commit it. And there was also a suggestion that the falsified records were for the purpose of tax fraud. So we'll see how this unfolds in the coming months. But it's also important to note that even if the felony enhancement is bounced by the judge or an appellate court, it's still likely that the misdemeanor charges for falsification of business records would remain. And those are still crimes. There just wouldn't be jail time associated with them. Now, in terms of defenses, Trump is going to have lots of them. Trump's criminal defense will probably be different from his public talking points. For example, Trump and his advocates have argued argue that prosecuting people for record-keeping mistakes is proof that the whole affair is just a witch hunt, since no one ever goes to jail for falsifying records. But that's not accurate. According to the New York Times, quote, since Mr. Bragg took office in 2022, prosecutors have filed 117 felony counts of the charge against 29 individuals and companies. So besides the court of public opinion, Trump also has viable legal defenses to these charges as well. Although the prosecutor doesn't have to get a conviction on the predicate offense, the second crime might be the best avenue to attack the record-keeping allegations. Expect Trump's lawyers to argue that the hush money payments were not in-kind contributions for campaign purposes. They were for the purposes of protecting Trump's family rather than influencing the election. Expect them to argue federal preemption, that the federal laws preempt state laws in this case, or that the federal laws can't be used as a predicate for the state laws at all. And as we discussed in our previous video about a potential Trump indictment, it's not at all clear whether all of these charges are within the statute of limitations. Since the last allegedly falsified record is from December 7th, 2017, normally the 5-year statute of limitations would be up, but during the pandemic, then New York Governor Andrew Cuomo told the statute of limitations by 228 days for COVID-related reasons. So this means that some of the charges are probably still timely. But those extensions might not be enough to bring in the other alleged acts. In any case, Trump's best defense is to get these charges dismissed on legal grounds before it ever gets to a jury, because there isn't likely to be much disagreement on the facts, but there are plenty of legal questions for the judge to deal with long before trial. Now, given the unprecedented nature of these proceedings, there's going to be a ton of Trump videos in the future. Sorry, or you're welcome. But there's so much stuff that I can't release everything on YouTube. But thanks to the power of today's sponsor, Nebula, you can watch all my videos ad-free and early, because all my videos always go up on Nebula first. Well, except for this one, because we had to write, shoot, and edit it in like 18 hours. But other than that, they all go up on Nebula first. And now for limited time, you can get a lifetime pass to Nebula, which is great because on Nebula, you get access to exclusive videos like the deep dive we took on Trump's mental state for the various crimes he's accused of, and the crimes that Steve Bannon was pardoned for. And my Nebula classes, which include my entire course on how to sue like a lawyer. And my first full-length documentary, Bad Law, Words Good. Those are just a few of the tons of exclusive videos that you get only on Nebula. So if you sign up using my link that's on screen right now or down in the description, you can get a lifetime subscription to Nebula. It's good for forever. Now, obviously, that's not going to be for everyone, so you can still get an annual subscription for just $30, which is 40% off the regular price. So sign up now and get a lifetime pass, or get 40% off by clicking on the link below and get Nebula for only $30 a year. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.